All right, and welcome back. This lesson is on interest and estates. We're going to cover freehold estates and leasehold estates and interest in land. All right, so interest. An interest in real estate is ownership of any combination of the bundle of rights to real property. Remember the bundle of rights? We had the right to possess, the right to use, the right to transfer, the right to encumber, and the right to exclude. Possessory interest are estates in land or estates. Private non-possessory interest equals encumbrance. So if your property, if there's an encumbrance, which means you may have a mortgage lien or some other creditor or a contractor who's done some work, they may have placed a lien on your property. That is private and non-possessory, which means they cannot possess that property. Then we have a public non-possessory interest. And that can fall under police power. We'll get into that. Okay. So interests are typically distinguished by whether they include possession. If the interest holder enjoys the right of possession, the party is considered to have an estate in land. If you possess it, that is your property. If a private interest holder does not have the right to possess, the interest is an encumbrance. If the interest holder is not private, such as a government entity, and does not have the right to possess, the interest is some sort of public interest. An encumbrance enables a non-owning party to restrict the owner's bundle of rights. This could be tax liens, mortgages, easements, and encroachments. Those are examples. And we'll get into those terms a little later. Let's talk about estate and land. An estate in land is an interest that includes the right of possession. Depending on the length of time, one may enjoy the right to possess the estate, the relationship of the parties owning the estate, and specific interests held in the estate. An estate is a freehold or a leasehold estate. We're going to talk about freehold estate. Freehold estate can either be fee simple, which you have all your bundles of rights, which includes absolute. Then under fee simple, we can have defeasible. Fee simple defeasible is a perpetual estate that is not conditioned by stipulated or restricted use. It may also be freely passed on to heirs. For these reasons, this is fee simple absolute. I apologize. I'm reading. Fee simple absolute estate is the most desirable estate that can be obtained in residential real estate, and it is the most common. That was fee simple absolute. Okay, now let's talk about fee simple defeasible. The defeasible fee estate is perpetual, provided usage conforms to stated conditions. Remember, there's a condition involved. If the use changes or if prohibited conditions are present, the estate reverts to the previous grantor or owner of the estate. Okay? With defeasible, there is a condition involved. I will allow you to use my property as long as you use it for X. If you're not doing X, it's going to revert automatically to me. And X can be anything that you want to put in there. All right. So before we go to the PowerPoint, let's talk about the two different types of fee simple defeasible. You can have determinable, which means the deed to the determinable estate states usage limitations. If the restrictions are violated, the estate automatically reverts to the grantor, which is the owner, or heirs. That's determinable. Then we have condition subsequent. If any condition is violated, the previous owner may repossess the property. However, reversion of the estate is not automatic. The grantor must retake physical possession within a certain time frame. Remember that. So under fee simple defeasible, defeasible meaning condition, we have two types of condition. Determinable, where you have the estate automatically reverts to the grantor or heirs. And then we have condition subsequent, where the owner must retake physical possession within a certain time. Ownership does not automatically revert with condition subsequent. Okay?